Hello, good afternoon. Thank you all for being here. We do hope everyone is well and staying safe. Today is Tuesday, October the 6th, and this is a live webinar on how to select the right trustee. My name is Ashley, and I'll be introducing our presenters. But first, a little background on Russo Law Group. We have focused on elder law, special needs, and estate planning since 1985. With over 35 years of experience, we've had the privilege of serving over 17,000 families in 4 convenient office locations, including Garden City, Lido Beach, Islandia, and Manhattan. We are a large firm consisting of 6 partner attorneys and 4 associate attorneys, and we are ranked as a best law firm by the U.S. News. In other recent news and events around Russo Law Group, you can watch Vincent as a legal correspondent on Catholic Faith Network's CFN Live. He will address the newest changes in Medicaid home care and other legal developments in elder law, special needs, and estate planning. Also, our next webinar on estate tax planning for married couples will be on October 20th at 1 p.m., and Vincent will be presenting on that as well. But now let's meet today's lead speaker, Miss Elena Puma. Elena has played a vital role to the success of the firm since joining in 1991. She's the senior partner and head of our estate administration department. In July 2017, she launched Russo Law Group's Alzheimer's and Dementia Caregivers Support Group, affiliated with the Alzheimer's Disease Resource Center. She's also served on the board of the National Academy of Elder Law Attorneys. Helping to facilitate today is managing partner Vincent J. Russo. Vincent is a certified elder law attorney, founding member, fellow, and 5th president of the National Academy of Elder Law Attorneys. He's also co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs. I just want to remind everyone that this is a live webinar and you may type your questions into the questions box provided on the Zoom toolbar. If you're on Facebook, you can drop your questions using the comments section. When sending your questions, please remember to include your email address. We will do our best to answer every question, but if we run out of time, we will follow up after the program. And finally, a brief survey will appear automatically in your web browser when you leave the webinar. Kindly take a minute and leave us your review. Okay, thanks for your attention. Vincent, if you would, please take it from here.
Thank you, Ashley. And welcome everybody on how to select the right trustee. And today, we're going to cover first, what are the different types of living trusts? Then move into what is the role of the trustee, what are the duties of the trustee, and then the all-important question, who should be the trustee? So I'm thrilled to have Elena, my partner, who does this work day in and day out. We'll take our videos down. We're going to give you a lot of really good information today. So let's start, Elena, with what are the different types of living trusts?
Okay, well, thank you, Vincent, and welcome everyone. And as Vincent said, we're going to go through several things today to help you and guide you through the decision-making process. And understanding a bit of a background as to trust will be helpful for you in order to make that decision. So there are many types of trusts, living trusts, and I guess what we're doing here is we're breaking them into 2 categories, revocable and irrevocable. So a revocable trust, the main purpose of that is to avoid probate, which would mean not having to probate somebody's last will and testament in order to distribute assets upon death. So a revocable trust is a vehicle. It's a vehicle to avoid probate, and all the assets that are within that trust pass by operational law upon death. So it becomes irrevocable upon death, but it's revocable during lifetime. It can be changed, amended, restated to meet with whatever your wishes are. A benefit of a revocable trust is that it really makes it a lot easier for your trustee to distribute the assets upon your demise in accordance with your terms of your trust stating what your wishes are. And in An irrevocable trust is similar to a revocable trust in terms of it also avoids probate and it eases the process of distributing the assets, but it also has some other benefits. One would be that you can do a type of Medicaid asset protection trust that will allow you after 60 months to protect the assets within that trust from a nurse for nursing home purposes for Medicaid. There are also trusts that allow you to save estate taxes. And there are also trusts that you can put in place, such as Safe Trust, which will allow you to protect your family or a family member with special needs or a family member with creditor issues or marital issues. So there are different types of trusts that your trustee can serve under. And these were just the two main categories that we wanted to present to you today.
Yeah, two additional points I would make on the revocable is in light of COVID and the pandemic, we realized the true benefit of avoiding probate because the courts basically were closed and shut down. And so access to assets of a loved one who passed away can become difficult from a timing standpoint. So the revocable trust was very helpful for some of our clients who unfortunately we lost. And irrevocable sometimes can scare people, but I would say this, that there are lots of ways of empowering you, either directly with provisions in the trust or ways that you can amend an irrevocable trust. So there are, as Elena pointed out, significant benefits to that type of trust. And so I would say don't write it off. Consider it when you're thinking about protecting assets from a nursing home or saving taxes or protecting family members. So the focus today is going to be really on the trustee position. And sometimes we hear the word fiduciary when we hear the word trustee. So Maria Elena, what does it mean that a trustee is a fiduciary?
It means that the trustee is serving in a capacity that brings with it liability, both personally and in a fiduciary capacity to that person. Meaning, if that person does not conduct his or her duties and responsibilities as that fiduciary, they can be held liable to the extent of the assets in the trust, or if those are insufficient, it can reach out to them personally as well. So it's a very serious job. So just to give you a sense about what the role of a trustee is. So a couple of the components to it. One, the trustee has to be loyal. This requires that the trustee administers the trust solely within the interest of the beneficiaries. So the trustee can't do something that he or she may think is beneficial to them or that they prefer. They have to be impartial and make sure that it's in the interest of the beneficiaries. The trustee must act prudently, which means the trustee must have an objective standard of care in managing and investing the trust property properly. So they can invest in something that's extremely risky because that would not be prudent. I mentioned already impartiality. So the trustee has to make sure that there is no favoritism between classes of beneficiaries. So for example, some beneficiaries may be entitled to income, and maybe they're the beneficiaries during the lifetime of the settlor, the person who created the trust. And then there are other beneficiaries who would be called, say, residuary beneficiaries, and their interests come into light upon the death of the settlor. So the trustee has to make sure that he or she acts in a way that treats both the income beneficiaries and the residuary beneficiaries in an even fashion, because they may not be the same people. The trustee must also make sure that the trust property is maintained as trust property and is not commingled in any way with the trustee's personal property. So for example, an asset, a bank account is going to be in the name of John Smith, trustee of the James Smith Revocable Trust. that doesn't mean that John Smith owns that. He's owning that individually. He's owning that in the capacity of his trusteeship. So he can't take a check that's payable to the trust to John Smith as trustee of the trust and put it in his John Smith bank account. Okay, so it has to be kept separately. Also, part of the role is in service is to make sure that you keep the beneficiaries informed, updated, that you account for your acts so that the beneficiaries can make sure that things are being handled properly, and to make sure they have an opportunity to question or ask if there's something that they're concerned about. So as long as that trust is in existence, the trustee has duties. It's only upon the final distribution of the trust, when legal title of all the assets pass to the beneficiaries, that the trustee's duty and responsibilities are completed.
So Maria Elena, I want to repeat something you just said, which is really important here. And that is, a trustee is personally liable if they breach his or her fiduciary duty. And you've made it very clear how serious the role is of a trustee and the responsibilities. Now, sometimes trustees get into trouble because they self-deal. So can you talk a little about that, self-dealing?
Sure. So self-dealing would be a situation in which the trustee does something that may benefit him or herself. So the general rule is that a trustee may not profit personally from any transactions with the trust property. That would be considered self-dealing, and that is an absolute restriction, violation. It's a no-no. However, the statute allows for self-dealing if it's permitted by the trust. And so if that provision is in the trust and there's a reason that allows for it, then the trustee may be able to enter into a transaction that may give the appearance that he or she is personally, benefiting from that transaction. But as long as the trust allows it, then that's a different situation. However, a stern warning here is that if that trustee is also a beneficiary, and any action that that trustee is taking that can be deemed self-dealing is going to be looked at very, very closely. So you have to be extremely cautious with that.
Yeah, tip that I would give would be that if you're a trustee and you are going to take an action which benefits you, you may want to call your attorney, your estate attorney, trust and estate attorney, and just ask them about what's permitted and not permitted. We often find ourselves, Maria Elena and I in our law firm, in a situation where it's after the fact, and the trustee may have done something inappropriately, maybe inadvertently even, but it puts that trustee on the hook. So I would say if you're a trustee and you're going to do something and you're going to personally benefit from it, you may want to run it by your trusted estate attorney first. So there are lots of duties, right, Maria Elena, of the trustee? Can you share some of them with us?
Sure, absolutely. There are many, and so we're going to look at these closer, but the collection of trust assets and income, the payment of trust expenses, the distribution of the income and assets, managing the trust assets, tax reporting, and accounting. So this is the overall list here that we're going to focus on them a bit closer. So let's take the first one, collection of trust assets and income. And Vincent, if you don't mind changing the screen, the slide to the next slide. Okay, so a trustee has the duty to preserve, protect, collect, transfer, sell, value the trust assets and the income. So a trustee has to say, okay, what's in this trust and what do I need to do in order to manage those assets? Are they invested properly? Do I need to do anything to protect them? Do I need to value any of the assets? Am I selling something? Am I selling a piece of real property? Do I need to get a certified real estate appraisal? to see what the valuation of that property is so that I am making sure that I'm acting properly in my duties to marshal the assets of the trust. So that's the first part. The second part is making sure that the trust expenses are paid and timely paid. So in this category, you have debts, liability, taxes, general trust administration expenses, which again could be like appraisal fees, and other types of expenses that are solely related to the administration of the trust, such as commissions and other types of expenses. So the trustee must make sure that these expenses, taxes, bills are paid up. Then ultimately, the distribution of income and the assets. So the trustee needs to look at the terms and the provisions of the trust. During the lifetime, there may be some dispositive provisions for income to certain beneficiaries. There may be opportunities to make distributions of principal in certain circumstances. But ultimately, when the settlor is deceased, the trustee will actually distribute the residuary of the trust, what's remaining, to the beneficiaries. So that would come as a final ultimate distribution.
Yeah, when you mention income having a tax background, I just want to highlight here, whenever there's trust income, the government's going to tax that income. And it can get a little complicated depending on the type of trust you have. If it's a revocable trust, then you set the trust up and you'll pay any tax on the income of that trust. If it's an irrevocable trust, it gets a little more complicated, and it might be the trust has to pay taxes, or the person who set it up, or even the beneficiary. And that's where you want to have competent tax counsel or an accountant involved to make sure that the trust files whatever tax returns they need to file and the taxes are properly paid. Now, you mentioned management of assets. So a trust is funded, let's say it's funded with real estate. Well, you are now, if you're the trustee, responsible to make sure that the real estate tax bills get paid and you make the necessary repairs. And if they're liquid assets, then you need to be also very careful when it comes to how they're invested. Liquid assets being stocks and bonds, annuities. These are assets that could be in the trust. So Maria Elena, talk about the responsibility here of the trustee in managing and investing trust assets.
Okay. So as I said earlier, the role of the fiduciary, the trustee in this case, is to be impartial and to treat the income beneficiaries and the residuary beneficiaries in an even and fair way. So certain types of assets result in a different type of return. So for example, stocks offer the opportunity for growth and may not have a lot of income attached to it, while bonds offer the opportunity for income but have little growth. And as you can see, well, if I'm an income beneficiary, I would rather the trustee invest in bonds. But if I'm a residuary beneficiary who's going to get the remainder of the trust after the settlor dies, I'm going to want investments in stock because that's going to allow the assets to appreciate. So the trustee has to balance and have a total return approach and have a portfolio that balances both of these types of investments that will treat the income beneficiary's interest and the principal beneficiary's interest in a even way.
Yeah, and I think as you frame this for those who are listening, the total return approach is the responsibility of the trustee. And I always recommend that we look at the provisions of the trust. And I know, Maria Elena, you always look at the provisions of the trust because you can alter how investments are made. You can, by providing for such in a document, you can express, for example, a preference to take care of the lifetime beneficiaries, which could be to the detriment of the remainder beneficiaries, the ones who inherit after the lifetime beneficiary passes away. So very important, the words count in the trust document, and especially here when we're talking about this general rule of a total return approach. And then that can be tweaked or altered depending on your own personal views and preferences, which can be provided inside the trust document. So what's great about a trust is it can be whatever you want it to be. And we can write in provisions to make sure that we're following your desires. Now, I got a little ahead of myself before, Maria Elena, on
Yeah.
taxes.
Okay.
So why don't you outline again, because I did it real quick, tax reporting and also this issue of accountings.
Sure. So, like Vincent just said earlier, I mean, I think he just made a great point, that you really have to look at the trust document itself, the four corners of the trust, and see what those provisions are. Because regardless of these main categories of general duties and responsibilities, you really need to focus on the trust itself and see there may be something special in that document that creates an additional responsibility to the trustee. So in terms of tax reporting, there's basically three types of taxes that are involved when you have a trust. That would be individual income taxes, fiduciary income taxes, and then ultimately estate taxes. So I'm going to focus first on the income taxes. So individual income taxes would be the income that's reported on the settler's personal income tax return. So in the example of a revocable trust, where the settler's social security number is the tax identification number used for the trust. It's a grantor trust, which means that the income that that trust generates is going to flow through and be reported on the settler's income tax return. So that is one type of income tax. The other type would be the impact on the beneficiary. So for example, if you have a trust that paid out income to the beneficiaries, to the extent that there was a distribution of income to that beneficiary, that income becomes what's known as DNI, distributable net income, and the beneficiary will receive a Schedule K-1 and have to report that income on his or her individual income tax return. So that's another way that there's income taxes generated from a trust. And another way would be actually having a trust fiduciary income tax return, which the trust has to file every April 15th. It's based on a calendar year, just like an individual. And the trust has to report the income that it generated. So in most of these cases, it could be, it's usually a trust that has its own tax identification number. And that's where that income is reported. So you'll see this most often when a revocable trust becomes irrevocable because the settler passed away, or you'll see this in the event of an irrevocable trust, such as a life insurance trust that is its own entity. In terms of estate taxes, this comes into play when the settler passes away. So when the settler dies, there's a requirement that federal and New York estate tax returns are filed, if applicable, and any taxes are paid. Just generally to give you a sense, for federal purposes, the value of the gross estate, which would include all assets, not just the trust assets, but all assets of the decedent. For federal purposes, the threshold amount is $11,580,000, and for New York State, it's $5,850,000. So that's the tax reporting that comes into play with the trust. In terms of the next section, which is accountings, this goes back to what we talked about earlier, where we marshal the assets, collect the assets, maintain the assets, invest the assets, and then we pay certain taxes, liabilities, expenses, and so forth, and then there's a net amount left. So we need to, as the trustee needs to account to the beneficiaries to show we started with this amount, we had expenses of this amount, and we ended up with the remaining amount. And those accountings can be done depending, you got to look at the trust. They may be required to be done on an annual basis. They may be required to be provided upon the request of the beneficiary. But in any event, you always need, at the end of a trust, to give some kind of an accounting. It doesn't have to be a formal accounting. It can be informal, but you need to account to the beneficiaries, because along with that, when that accounting is done, the trustee needs to get a document signed by those beneficiaries, basically stating that they have received what they were entitled to, that they release the trustee from liability personally and as a fiduciary. Because you want to make sure that when you're serving as trustee, that you're protecting yourself from any further exposure. So those are documents that usually get put together along with the accounting. Those documents are often referred to as receipt, release, refunding, and waiver agreements. And those would be required for the beneficiaries to sign in order to get their ultimate distribution.
So we've seen a good number of problems when it comes to this whole area of accounting to the beneficiary. So I think the tip here would be is keeping good records, canceled checks, bank statements, keep a record of all the assets you have, all the distributions of any monies out of the trust, the record keeping, the receipt of all the income coming in. Just so important because even good families, we've had situations where everybody gets along and everybody's good with each other, but at the end, one family member says, one sibling to the other, how do I know I'm getting everything I'm entitled to? I want to see an accounting. So I think that's really important.
Yeah, documentation is key because you really need to protect yourself as trustee.
That's right. So let's move on to compensation. Is the trustee entitled to be paid for doing the job of trustee? And if so, what should they be paid? Maria Elena?
Sure. So the trustee compensation, which is often called trustee commissions, can occur one of two ways. One way would be as provided for in the trust agreement. So as we said earlier, you need to always read that trust agreement because there may be provisions in there that change what the normal statutory course is. So there may be a provision in the agreement that says my trustee is entitled to a commission of 5% or whatever the provision is. So if that's the case, then you follow the terms of that trust. What is more likely is that the trust document says my trustee is entitled to compensation in accordance with New York state law, which provides for statutory commissions. So that's what I'm going to focus on here. So again, unless the trust states otherwise, it's going to be the compensation is going to be the New York State statutory commissions. Now there are 3 sub-commissions for a trustee. I'm going to start with the payout commission. The payout commission is a once-in-a-lifetime commission of 1%, which is payable upon the final settlement of the trust. So if the principal of the trust is $1 million, once the trust is terminated and the trustee has done all of his or her duties, that trustee has earned a commission of $10,000. Okay, so that would be the final payout commission. It's based upon the principal, and it's only paid out once upon the settlement of the trust. The second kind of commission is the annual commission. And the annual commission is just that. It can be paid annually. And the way the annual commission works, it's payable 1/3 from the income of the trust, and it's paid 2/3 from the principal of the trust. So the annual commission has a formula. So just to give you a sense, on the first $400,000 of the trust, you're entitled to $10.50 per 1,000. And then on the next $600,000, you're entitled to $4.50 per 1,000. And then you're entitled to $3,000 on any principal that's additional. So to give you a sense, on $1 million, an annual commission would be $6,900. 1/3 of that would be paid from income, and 2/3 of that would be paid from principal. If there is no income, then you cannot get paid that 1/3 piece if there's not sufficient income. Now, 2 points I want to make. In order to be entitled to receive that annual commission, you have to go back to the trust document and see what the provisions are there with regard to accountings, because often there's accounting provisions in the document that say you must account to the beneficiaries once a year or twice a year, or you don't have to account, because that's going to play in to whether or not your trustee is entitled to receive those annual commissions. The second point I want to make is often the trustees don't take the annual commissions during the person's lifetime, but they want to receive them at death, once the settlor passes away. So the rule is that if you fail to take an annual commission, you don't automatically waive it. So if somebody served as trustee in 2018, 2019, and 2020, and the settlor died in 2020, the trustees can still go back and get annual commissions for 2018 and 2019 to the extent that there is income and principal available. So you don't waive it by not taking it. The third type of commission is a real property management commission, and that's in the case of property owned in a trust that's used for rental purposes. So the trustee is entitled to a 6% commission on the gross rent. So that would be the third type of commission.
All right, so this can get a little complicated here with the different ways the New York State statutory commission works. And as Maria Elena pointed out, your starting point is the trust document. So the trust document can either fix what the compensation is, it can provide that there is no compensation. So often when we have family members, spouse and children as trustees of a trust, there may be a provision that says if you're a family member, then you're not entitled to a commission. Also, when you're paid a commission, it's subject to income tax to the person who receives the compensation. So one would question whether they would want to take a commission as a trustee if they're also the beneficiary, because they may receive the funds as a beneficiary without a tax. But if they receive some of those monies as a commission, then it would be subject to income tax. And then lastly, so families sometimes, even though the document says you're entitled to reasonable compensation as a trustee, they waive the fees. So there are choices here. What's really important is to discuss the options, make sure the attorney explains them to you, and that you understand what they are, and then make a decision how you want to provide in your trust instrument. So Maria Elena, let's move on to some of the common mistakes of a trustee and how that also can lead to personal liability, and how do we act in a way not to have that situation?
Sure. So first of all, from what we've seen, looking back at their responsibilities and their duties and what their ultimate role is, we have to make sure that the management of assets was proper. So we often see improper management of assets. We often see improper investment of assets. We see the failure to file tax returns, or the late filing of tax returns and the late payment of tax payments. We often see the failure to maintain proper records in order to provide that accounting. Like Vincent said, it's important to document everything that you do. So these are the common mistakes that we see, and this creates a potential risk to the trustee, again, both personally and as the fiduciary. So in order to minimize that risk, the trustee needs to engage professionals that will help him or her serve and to perform their duties properly. And there are, again, we go back to the trust document, look at the salient provisions of the trust. There will be provisions in there that will say the trustee is allowed to hire professionals such as investment advisors, financial advisors, accountants, lawyers. That provision is put in there intentionally so that the trustee can retain proper representation so that he or she can do his or her job properly. So my recommendation here is when you select your trustee, and oftentimes the trustee is usually a family member, like a spouse or child or a sibling or even a friend, you may even want to consider appointing a professional trustee, like an attorney or an accountant, to serve as a co-trustee with your lay, for lack of a better term, lay trustee, family member, or friend, to provide that further guidance and direction. But in any event, you know, the trustee should always seek the advice and counsel of a trust attorney for guidance through the entire administration process. There's just too much at stake here.
So I think to summarize on this one, to avoid all these mistakes that potentially can happen and that a trustee could make, which not only may adversely affect the trustee, but also the beneficiaries as well, like the improper investment of assets. Selecting the right trustee is really the key. That's the tip. So the $64,000 question, Maria Elena, is who should be the trustee?
It's a really good question. You really have to take into your decision-making process what we've talked about today, the different type of trusts, what those trusts say, what the role of the trustee is, what are the duties of the trustee. You have to think about, again, it's usually a family member or a friend. Do they have the knowledge? Do they have the time that they can serve in this capacity? If not, do you appoint a co-trustee to serve with them? Maybe somebody who is a professional advisor. There's also corporate and trust companies who serve in that capacity. Often, though, they won't serve as a co-trustee with a family member or a friend. And I just, as an aside, mentioned that the corporate trustee rates are higher than the individual trustee commission rates that we talked about earlier. So it's a very, very important decision. You have to take all of what we talked about, all these factors into play, and figure out who do you think you can give this job to, and who will be able to successfully serve in that capacity, and make sure that your wishes are implemented.
So what we commonly see, Maria Elena, are family members or trusted friends named as the trustee. That probably would be most typical, would you say?
Yes, I would say.
And then when you get into irrevocable trust to save estate taxes or family protection trust, generation skipping trust, that's where a professional advisor may well come into play as a trustee, or as Maria Elena mentioned, a co-trustee. There are banks, trust companies that will act as a trustee. And you mentioned, Maria Elena, that they have their own fee schedule, which is typically higher than the New York State Statutory Commission.
Correct. And then often they actually have their own. There are corporate trustee compensation commissions in the New York statute, but then corporations also sometimes have their own schedules for those commissions as well.
Right. Now you head up our Trust and Estate Department, and we represent fiduciaries day in and day out. Literally, we've represented thousands of estates and trusts through the years. And so we found that there was also a need sometimes for a professional trustee or executor, and maybe because there was no one in the family available, or maybe there were family available, but they weren't suited for the job of being an executor or trustee, or a trust was going to last a really long time, and they wanted to make sure they had someone in place and a plan in place for continuity on how the trust would be handled. And in those situations, we have offered ourselves as trustees of those trusts in those situations. And so I'm acting as a trustee in a number of different trusts. Some of them have been court ordered. Many of them are connected to a beneficiary who has special needs. And so that is an option that we offer in our firm for our clients. Anything you want to add there, Maria Elena?
No, I agree with what you said. Sometimes there are cases where there just isn't a family member or friend, and the clients ask us to serve in that capacity, and we can assist them in that regard.
All right, great. So we're going to give a quick summary here. Before we do, I want to just circle back to the most common trust that exists, which is the revocable living trust. And it's often a trust, as Maria Elena pointed out in the very beginning, that avoids probate. And it is typical that the person who sets up the trust is also the trustee. So a lot of the concerns we've addressed about management and accounting and commissions being paid to a trustee, they really don't come into play when you set up your own revocable living trust and you're the trustee of that trust during your lifetime. But of course, you are going to provide for a successor trustee if you became disabled and unable to manage as a trustee, or upon your demise. So different types of trust will raise in level of importance the points we've made today. And so the starting point really is to, when we meet with our clients, is really to talk about the different types of trusts and make sure that they meet your objectives. And then from there, we'll go through the discussion we just had with you, getting into the roles and the role of the trustee and the duties of the trustee, and help you with the selection of a trustee. So sometimes clients, they won't, they don't even want to come in. Let's say if we get an inquiry from someone living in the community, they don't even want to come in if they don't know already who the trustee is. No, come in and see us. We're more than happy to talk to you about the options and figure out with you who could really step in and be that trustee for you. So that's an important point that I think both Maria Elena and I feel very strong about, which is come in first and let's work it out together. Any other additional thoughts here in the summary, Maria Elena, before we move to Q&A?
No, I think you got it all.
Okay. Also, we got a comment from Rick Shalafo, who's is very involved as a corporate trustee, and he states many corporate trustees are willing to serve with an individual trustee. So that's that co-trustee situation. He says that they often do, and trustee fees is sometimes less than an individual when you break out the trustee fee from the investment management fee, which is charged to the trust, whether with an individual or corporate trustee. So what he's saying there is you have a fee you pay the trustee for doing the job as trustee, and there could be a fee separately if you're paying someone to professionally manage. And if you're utilizing a trustee who will also do that, they'll build that into the overall fee. So it's a very, very good point that he makes. So Maria Elena, we're going to put our videos on, and I see there are a couple questions that have come up. And so I'm going to give you all the hard questions.
Okay. I'll do my best.
I'm going to keep the easy ones. Maria Elena, can you talk about the need to have a successor trustee named in the document?
Sure. It's very crucial to have a successor trustee in the document. So for example, Vincent used the example of the revocable trust where the settlor during his or her lifetime may serve as sole trustee. Upon that person's death, you have to make sure there is a successor appointed who can step up and continue. In any trust, You never know what's going to happen with your primary trustees. Things can happen. They can become disabled, or they can choose not to serve, or God forbid they should die. So you need to have a successor trustee in place, and you can have those provisions built into your trust.
Okay, very good. The next question is, it has to do with estate taxes and whether all trusts are included in the estate of the person who sets it up. So I think you made the point, if it's a revocable trust, those assets are included in the estate. But what about irrevocable trusts? Are all of them also included in the estate of the person who sets it up?
You have to look at the specific irrevocable trust, and you have to look at the terms of that trust to state whether or not they're included in the estate. Now, sometimes it's an irrevocable trust and there's intentionally a power that's given, such as a power of appointment, and it's done for tax purposes to bring it back in for a step up in basis, versus other trusts that may be completely like a irrevocable life insurance trust. Something like that would be excluded from the gross estate after a 3-year period. So it depends on the irrevocable trust. You have to look at the trust itself.
Yeah, I would say, as just a general rule, if it's irrevocable and you're doing it to avoid estate taxation, then if it's properly drafted, then it will not be included in the estate subject to tax. There was another tax question here. I'll take it on this one, which is, the question had to do with which rates are higher than individual tax rates or the trust income tax rates at the federal level. And so clearly, when you run up the brackets, you'll pay a whole lot less in taxes when you're taxed at the individual rate versus the trust tax rate. When you get to around $13,000 of taxable income, you're in the 37% tax bracket for a trust income taxation, where you could be in the hundreds of thousands of dollars of taxable income before you get to 37%. So often we build in tax planning whenever we handle any of these trusts. And then my loyal contributor to this, our webinars, Corinne has a question, longstanding client of the firm. And Corinne's question is, if an individual has assets outside of the trust, will the settlement of the probated assets delay the distribution of the trust assets?
Oh, that's a good question. It depends. You have to look at what the will says. So assuming that the assets outside of the trust, let's say if they're probatable assets, if they're non-probate assets that have, for example, joint beneficiaries or designated beneficiaries, or if they're payable on death or transfer on death to somebody, those won't impact the trust. However, if those assets outside of the trust are probate assets, you need to look to the will. So then you have to look at, if you're probating the will, what are the terms of the will? Does the will stand alone and have its own dispositive provisions? Or is the will what we call a pour-over will, and meaning those assets eventually get poured over into the trust to be distributed in accordance with the dispositive provisions of the trust? So the answer here is it depends, and that may not prevent a partial distribution from the trust if it's a pour-over will, but it may, depending on what the situation is. Is the will going to be contested, or is it not going to be contested? So the answer is here, it depends.
Yeah, and that's what makes life so interesting for us as planners and for our clients, because everybody's situation is different. And depending on the type of assets, your objectives, your family, your personal health situation, all these are factors that come into play when we put together a comprehensive estate plan for you. So the key is, don't wait. If you don't have a plan, especially in light of the pandemic, please take steps. Meet with an experienced estate planner. We're more than happy to help you. And you can schedule an appointment by calling our office. And Ashley is always available, and Mary, to answer any questions you have, or if we need to get an attorney on the phone, up front to answer your questions before you come in. So the key is, though, implement a plan. And if you have a plan, then make sure you're reviewing it periodically because life circumstances change. So I want to thank Maria Elena for really giving a very thorough presentation on how to select the right trustee. And Ashley, I don't know if there's anything else you want to add before we sign off. Maybe, I know we usually have a survey afterwards.
Yeah, I think you covered it, but there is a survey that will appear in your web browser automatically when you close out of the webinar. So I would like to thank you in advance for your review. And as always, thank you for attending.
All right, everybody have a great day and be safe.